Good morning. My name is Ted McGinn. I'm the managing partner at Lavelle Law, and this is another installment of our breakfast briefs. Today, we are going to present a program called Navigating Divorce, and we are happy to have a great panel for us today. We have Emil Allcast, Colleen Hurley, Christina Allcast, and Patty Levinson who are going to present various topics concerning divorce. Now, before we jump into that, you may be wondering, what is Lavelle Law doing during this pandemic in the last couple of months? Well, we've been doing our best to try to attend to our client needs as much as possible, but doing it in a safe and healthy manner. We have all of our attorneys are equipped to work remotely from home. They all have access to their emails and are taking phone calls and have access to the client documents that they need in order to work. We're continuing to operate in a safe and healthy manner. Some other things we've been doing, which is kind of unique in how we've adapted, is that we, in our estate planning group, for example, we've been doing remote execution of estate planning documents. So anybody who really needs an estate plan executed, you don't need to be worried about having to get face-to-face with witnesses. So that's one area that we've adapted. We've also been having real estate closing documents executed remotely. We've conducted depositions remotely, presented court filings and court hearings remotely. So Lavelle Law, we've been adapting as best we can. We still want to strive to serve our client needs, but we've been doing it in a safe and healthy atmosphere. We want, obviously, our employees to be safe, but we also want our clients to be safe as well. We're going to jump into our presentation now. Throughout the presentation, if you have questions, you should please type them into the prompt. We'll hold off on questions and answer those at the end of the presentation. But throughout the presentation, just go ahead and type those in, and we'll tackle those as best we can. Also, for those who are interested, we are certified by the Illinois Department of Financial and Professional Regulation as a public accountant CE sponsor. So anybody who's interested in getting some sort of credit, let us know, and we'll do what we need to help you out with that. Also, if anybody's interested in getting a copy of the PowerPoint, please email us at info@lavellelaw.com. And of course, if you have any other questions that occur to you later on, by all means, reach out to us. We'll be happy to tackle those questions. So we're going to jump into this now. First, we have Emil Allcast, who's going to talk to us about property settlements and maintenance. Emil, take it away.
All right, thanks, Ted. Good morning, everyone. So when we think about divorce, there are a number of components in a divorce case. What I will focus on primarily would be just property settlements and issues that are financial. So issues of allocation of marital assets and debts. We've got the issue of maintenance, which some people refer to as alimony. And then there's the issue of child support. So when we look at a divorce case, one of the things that the court has to do is determine which assets in the marriage are either marital or non-marital. And so Illinois treats, there's a presumption that Illinois courts have that when property is acquired when somebody is married, that's presumed to be a marital asset. Now, the person that says or wants to challenge that and say, no, this asset is not marital, it was mine for XYZ reasons, they can overcome that presumption. And so with the Illinois statutes, what is deemed non-marital are things that like you acquired through a will. So if Uncle Joe passed away, gifted you $100,000, that would be separate. So that's non-marital. So in a divorce case, that would not be divided. Or if you have assets that you came into the marriage with, for example. So somebody with like a second marriage, for example, has property or a house, business that they've had prior to marrying spouse number two, typically those assets would be separate. And then, so the statute lays out, there's 8 different factors or 8 different ways to keep assets non-marital. So in a divorce case, a judge is only really dividing marital assets. So one of the biggest marital assets that most people have is real estate. And for real estate and businesses especially, those are divided, and courts will typically not want to share or make exes business partners after the divorce. So for example, with real estate, there are several things that a court can do. Number one is they can order the property to be sold. And so they would assign a realtor to list a property for sale, get that property sold, pay off all the debts that are associated with that property, and then whatever is left, divide that between the parties. Now, just to back up a little bit, so Illinois is not a 50-50 state, meaning court doesn't have to divide everything evenly. So that's what we call community property, and Illinois is not a community property state. What we do have here in Illinois is an equitable distribution. So what's fair? And then that's what the court has to look at. So sometimes fair is 50-50 with all the assets between the two parties. Sometimes it's not. Sometimes it's better to, or it's more fair to give one party 55% of the assets and the other person 45% of the assets. So that's how courts usually determine division of marital assets and how much somebody gets. So with real estate, there are typically like three ways of how that's divided. Number one is sell the property, split the proceeds between the parties. The second way is to buy somebody out. And so what that means is spouse A wants to keep the house. Spouse B says, okay, fine, but I want some money if I'm going to give this house up. And so typically the way this is done is you would figure out how much equity is in the property. So equity is typically, the appraised value of the house minus any loans or any obligations that are tied in with the house. So basically, what is your walk away price if you were to sell the property? And so that is divided in a way that one person would keep the house and they would either refinance the mortgage or somehow remove the other person's name from the mortgage. And then that person, in exchange of that, would sign over a quitclaim deed, giving them the physical asset of the house. And then the other party would get a portion of the equity, usually 50%. Now, with businesses, it's almost the same thing. So with the business, court's not going to want to tie in these two people that are getting divorced into the same business. So they're either going to ask that the property be sold and split the proceeds, or one person buys somebody out of that marital asset. Debts. So debts are very similar to assets. How were they acquired? Who incurred the debt? And those are some of the questions that the court looks at. So if somebody had $10,000 of credit card debt prior to marrying their spouse, that $10,000 is usually, in the divorce case, deemed non-marital, and so that's not a debt that the other party would have to contribute to. So it's very similar. So if there is a debt that somebody wants to say that this is a marital debt, they would have to show evidence that whatever debt that was incurred was for the benefit of the marriage. So somebody that has a credit card bill from Target, for example, and it's $5,000, and they want to say, well, this is all marital, the person challenging that will have to go through and essentially piece through all the credit card purchases and explain to the court why this didn't benefit the marriage. It's a difficult burden to do sometimes, but a lot of times you do want to challenge the allocation of the debts because that is just as important as the assets themselves. So taxes, there are several issues when dealing with taxes in a divorce. So in exchange for property, so typically when you sell or buy property, for example, like real estate, you would have to pay what's called capital gains tax, things like that, when you're acquiring new debt from somebody else or new asset from somebody else. In a divorce case, so property that's divided between the parties is not a taxable event, and that's something that's just written into the tax code itself. So if I got divorced from my spouse, anything I acquired, I wouldn't be paying any income tax on or anything of that sort. Ted, can we go to the next slide? Okay, so when dealing with divorces that have children, we run into the issue, obviously, of child support, and then there's maintenance. So what's the difference? So child support is support to help raise children. So when parties get divorced, one spouse will have primary possession of the children. So one party will typically have more days in a calendar year with the children than the other spouse. And so they're entitled to what's called support. Now, child support is to help pay for expenses that are incurred by children for their day-to-day living expenses. So it's an amount that is set by statute, and that law has changed. So before 2016, the courts looked at how many children the parties had, and they would base child support on the number of children. And they would only look at one person's income to determine how much that person should be paying. Since 2016, that law has completely shifted to what's called income shares. And what that means, just in an easy, quick fashion, is that the courts will look at now both parties, so both mom and dad's incomes, to determine what child support should be. And so there's a formula that is set forth by the statute. You would determine what the person's income is, what the other person's income is, and the number of children. And then the formula would tell you how much you should be paying. There's a caveat to this, though. If one party has the children for 146 or more overnights, then child support is significantly reduced, because what that means is, excuse me, is that if you have 146 overnights, theoretically you're having almost equal time as the other parent. And so instead of one parent paying the other parent child support when they have the kids, and then vice versa, and they go back and forth, the court sort of eliminated that by having this caveat that if a child is with one parent for 146 nights or more, then child support would be reduced. Maintenance is completely different. So maintenance, or alimony, is support for the other spouse. So many times a spouse was either a stay-at-home spouse or gave up a career to raise children, and it just wasn't able to support themselves after a divorce. And so the courts thought the best way to address this is to have one spouse pay the other spouse maintenance. And what that is to support that spouse, to help them get on their feet, so to speak, and to be able to be self-sufficient, or to allow them to have some support financially while they're doing things to get themselves up to speed or up to a position where they can become self-supporting. For example, going back to school or getting some training that could take months or sometimes years to build up to where you were prior to the marriage. And so maintenance is calculated, again, with its own little formula, and that is based typically on the length of the marriage. And so the duration of how long somebody will be paying maintenance is typically based on how long they've been married to their spouse. And so they look at day one of marriage, and then the second number they look at, or second date they look at, is when the divorce was filed. So if somebody was married and they filed a divorce within 5 years, they would receive maintenance for a shorter period of time than a couple that's been married for 15 years, for example. Now, maintenance is, again, based on a formula, but just briefly what the formula is they look at the person that's paying maintenance. It would be 33% of their net income. And then they look at the person receiving maintenance. It'd be 25% of their income. So whatever that difference is between those two numbers is typically what they would be paying a month for maintenance. Attorney's fees is another issue that's typical in a divorce case. A lot of times the question I get is, my spouse filed a divorce. She's the one that wants to get divorced. I don't. Why should I have to pay for this? Well, unfortunately, you do. So Illinois is a state, and almost every state in the country is the same way. Everybody pays their own fees. Now, sometimes you can get the other side to pay your fees or get an advance or assistance with paying your legal fees. So number one is, if a party just can't afford to pay legal fees and the other spouse is the person that controls all of the financial assets in the marriage, that person can go to court and ask the court essentially for like an advance on their marital estate. So you're basically saying to the court, I cannot pay my own fees. My spouse can't afford to pay for my lawyer. And the court would typically award you attorney's fees. So if the court says, I agree with you, you can't pay, so we're going to make your spouse pay for this divorce, here's $10,000. That means at the end of the case, you'd be getting $10,000 less because you've already received it in advance. The other way to get attorney's fees typically is through the powers of contempt. So if somebody was ordered to do something and they didn't follow through on that court order or violated a court order, you can bring them back to court to force them to do what they were supposed to do. And because you have to hire a lawyer to enforce an order, the courts would reimburse you essentially from the other side because it was their fault, so to speak, to be causing you to hire an attorney and bring them back into court and incurring all these costs for something they should have been doing from the first place. So those are usually the common ways of getting attorney's fees. Divorce experts are extremely crucial in a divorce case. And those experts could be like a real estate appraiser, a financial planner that can assess future earnings, business appraisals. A lot of times the courts just don't know what the value of something is. And so they rely on experts to tell them the value of X, Y, or Z. A lot of times you can also use an expert if somebody says, for example, they need alimony or maintenance because they have a medical injury that they cannot work. And a lot of times you can get what's called a vocational expert or even a doctor to examine a client or a party to assess whether they're able to work or generate income. Ted, if we can just shift to the next slide, please.
All right, Emil, thank you.
Okay, no problem. Thank you.
All right, so now we're going to move on to the next topic, which would be child considerations. Colleen Hurley is going to speak to us on those particular issues. Colleen, go ahead, take it away.
Thanks so much, Ted. Next slide, please. All right, so in many of the cases that people are facing in family law, there are child considerations. So that means children are involved in cases having to do with divorce or also parentage cases, meaning matters wherein the parties have children in common, but they may not be married. One important thing to look at when we're talking about child's considerations in family law is the 2015 Parentage Act, which is what we look to right now. That's what we use. It improved upon a previous Parentage Act. With the recent changes we see in the 2015 Parentage Act, it's important to be familiar with new terminology. I hear a lot of the old terminology still going around when talking to opposing counsel or clients, but it's important to know that in this particular Parentage Act, when you hear one word, it's referring to this previously used word. So the first one to know about is parental responsibility, formerly known as custody. Lots of people seem to believe that custody means having physical possession of a child, and that's not necessarily the case. Parental responsibility, formerly custody, means decision-making over a child, over major issues. It doesn't necessarily have to do with physical possession of a child. That is actually what we call residential parenting, which is a separate consideration. The next one is parenting time, formerly known as visitation. Essentially, it means your scheduled time with the child in this case. The next one is an allocation judgment / parenting plan, formerly known as joint parenting agreement. If you had what we called a custody judgment put in place before this 2015 Parentage Act, it would have been called a joint parenting agreement, or JPA. If you would have had a case after the establishment of the 2015 Parentage Act, we now call it allocation judgment or parenting plan. What it essentially is a detailed document entered by the court that details all of the terms of your co-parenting. So it should detail parenting time schedules, allocation of parental responsibility. It should talk about what happens on the holidays, what happens for vacations, what happens for school. It should be as detailed and as exhaustive as possible, because the hope when this is entered is to avoid these parents coming back to court in the future over every little thing. We want to do our best to be as forward-thinking as possible to address any major issue that may come up in co-parenting and get ahead of it, so we could have something in place that hopefully is workable for the life of this co-parenting arrangement. Next slide, please, Jen. Thank you. So under the Parentage Act, the public policy intent was to recognize the right of every child to physical, mental, emotional, and financial support of his or her parents. So an important thing to note here is that the parent-child relationship extends equally to every child and to his or her parents, regardless of the legal relationship of the parents. So there are better rights for a child when their parents are married versus not married, for example. Minor child issues come into play similarly in both parentage, meaning parents who are unmarried, or in divorce cases. Next slide, please. Lots of questions I get is how parentage is established. So when we're dealing with a case where the parties weren't married around the time of the birth of the child, what the courts look to is something called a voluntary acknowledgement of paternity, otherwise known as a VAP. Therefore, rebuttable presumptions of parentage that the court looks at, and we can get into detail on that later if there are questions about that. But what the court wants to know is who are the parents of this child and can that be established? That's the most important thing to do before you can get into the meat of a parentage case or a case involving children. Lots of questions I get about that are, what can happen with a DNA test when it comes to whether there are questions as to the establishment of parentage. One important thing to know is you can only bring a motion for DNA testing within 2 years after when you've learned or should have learned about relevant facts leading to a proposed challenge of parentage. The courts can still deny motions for DNA testing under certain circumstances. Lots of it depends on a case-by-case basis. And I'm happy to talk about that in more depth if there are questions at the end. Next slide, please. So parental responsibility, we touched on this briefly, formerly known as custody, but what it means is decision-making for the child. This includes major decisions such as educational, religious, extracurricular, and medical decisions for children. So when we're looking at an allocation of parental responsibility between co-parents, we're looking at whether there should be something called a sole allocation of parental responsibility, formerly known as sole custody, or shared parental responsibility, formerly known as joint custody. What it means is, are we going to have one parent who's making all of the major decisions for this child solely, or are these parents going to be working together to make those major decisions? Generally, what we see is the court does presume that both parents are fit to make decisions together, unless we see something otherwise in the case. Many considerations that the court looks to in making this determination is the ability of the parents to communicate. Communication is absolutely crucial when it comes to co-parenting because major decisions are going to pop up very frequently over the co-parenting life of the parties. It pops up when you're looking at what school to enroll your child in, what medical treatment they should be receiving, what religion you should raise them in, just to name a few. Other considerations are the interests of the parents, the fitness of the parents, whether there are any safety considerations at play, and of course, the best catch-all, which is the best interest of the child. We see many parents able to make decisions very well together, and they have a shared allocation of parental responsibility, but there are certain situations that call for just one parent to have sole allocation of parental responsibility and be the only decision maker. In order to establish that, you would have to show to the court, if you were the person who's seeking sole parental responsibility, the reason why you should have sole decision making and the other parent shouldn't. And a lot of that would include allegations about your fitness as opposed to the other parent's unfitness. Next slide, please, Ty. Parenting time, otherwise formally known as visitation. What this means is a schedule for when each co-parent will have time with his or her child. This is a question I get asked a lot, is what is normal parenting time? And what I would say here is there truly is no one-size-fits-all approach. There is nothing in a statute that says one parent has weekends and the other parent has all the weekdays. That's just not true because every family is different. And every child is different as well. So there are many considerations we look at when it comes to determining what parenting time should be. an important one, is the schedules of the parents and the schedule of the child, because what we're looking at is a schedule that works well when a child is out of school, out of activities, and the parents are out of work and home and able to parent. Another one is distance between the households and fitness of the households. In many instances, there are parents who are able to have something called shared parenting time, which means roughly 50-50 parenting time down the middle. But one important thing to consider with that is these households generally have to be pretty close together in order to actually make that workable. A next consideration, as always, is safety. If there are any safety concerns, that's certainly something that needs to be taken into consideration. If there are major safety concerns, the court can enter a supervised parenting time schedule if it finds that to be appropriate. And after that, of course, the best catch-all, which is the best interest of the child. The general presumption is that it is in the best interest of the child to have close and frequent contact with both parents, unless there's another consideration at play. And these schedules can include a regular schedule, which is the normal parenting time schedule that co-parents enjoy most of the time, and then separate schedules. What happens for school breaks, what happens for vacations, and what happens for holidays. We try to think of all of this in an allocation judgment. So these parties and the child have a good sense of predictability about where this child is going to be when. Next slide, please, Ted. Mediation is a great option in cases having to do with child matters. It's a requirement for courts when there is a dispute as to one or more co-parenting issues prior to litigation. So it's a great option if the parents aren't able to agree on at least one issue having to do with co-parenting. So that could be something as simple as what the parenting time schedule should look like for this particular holiday. Or it could be something bigger as to who should be the one making major decisions for a child. I've seen mediation be very successful in a lot of cases where the parties are just butting heads, and sometimes all it takes is sitting down with a neutral third party to talk through these issues to come to an agreement. I've seen it be incredibly effective. So that's prior to having an allocation judgment in place. But once you do have an allocation judgment in place, many of the good allocation judgments out there also have a requirement in place there that say that mediation is something that should happen if the parties are having a dispute down the line about a major issue before they go running into court, except, of course, in the event of an emergency. So that's a great safeguard to help keep these folks out of court and have unnecessary litigation and handle matters through mediation first if possible. There are private and public options available. Private mediation can be a bit expensive, but I think is completely worth it. And public options are also available, which are free of cost. The one downside is they can be very busy, so you would have to be on a waiting list in order to get in, but they are very great as well. And I do understand, that there's remote mediation available right now while the courts are closed during this pandemic, which is a great option too, if you're in the middle of a case right now and trying to move it along. The next issue are child representatives and guardian ad litems. So who are they? They're attorneys who are often appointed to a case after mediation fails or otherwise as the court sees fit. The differences between these. A child representative is someone who could be appointed as an attorney who advocates for the best interest of the child through litigation, advocates for the child as a lawyer. And a guardian ad litem is a little bit different. A guardian ad litem is an attorney who's appointed to be the eyes and ears of the court through investigation. And that attorney ultimately makes a report to the court recommending what he or she believes to be in the best interest of the child when it comes to the matters in dispute. Next slide, please. Mental health providers. In many cases, I've seen children have their own mental health provider, and it can be a great tool for everyone, including children going through family law matters. So in some cases, a child is seeing a mental health provider during the pendency of a case. One thing to note here is a child is entitled to a reasonable degree of confidentiality while seeing these providers. The law provides all counseling sessions shall be confidential. The communications and counseling shall not be used in any manner in litigation, nor relied upon by any expert appointed by the court or retained by any party. So the intent here is mental health providing for a child should not be used as a tool or a weapon in litigation. Parents can notify the provider of any changes in parental responsibility or parenting time. That is important, but it shouldn't be relied upon or used in litigation in this way. Next slide, please. Child support, Emil already touched on this, so I'll move on. Next slide, please. Allocation judgment. So we touched on this already, but it's the ultimate custody judgment in your case when custody was formally adjourned. Provides for all terms of co-parenting, parental responsibility, residential parenting time, which simply means where the child is living more than 50% of the time, and parenting time. And this can be arrived through either agreement of the parties, which is very common, with the help of mediation, which is a great tool that we talked about, with the help of a child representative or guardian ad litem through defaults. And what that means is if one co-parent is not participating in the case in any manner, the court can enter a default allocation judgment based on that, or through trial. Next slide, please. College expense consideration. This is one I get a lot, especially when we're on the precipice of graduation for lots of children and parents are looking to the future about what's next for their child. Often that's college. In Illinois, a court can order a parent to pay for post-high school educational expenses. This can be college, but this can also be a technical or vocational school. This considers the respective financial abilities and resources of the parents and child as equity may require. Only for good cause shown can the obligation extend beyond the age of 23 for the child. And the obligations include tuition and fees. We use the University of Illinois at Urbana-Champaign as the benchmark for the cost of this. Actual housing costs, actual medical expenses, reasonable living expenses, cost of books and other supplies necessary to attend college. And if you have any questions about any of this, feel free to reach out to us in the question and answer section. Thank you.
All right. Thank you, Colleen. Great presentation. We're going to move on to the next topic, which would be orders of protection. Christina Alkes, you're on.
Thanks, Ted. Thank you. So the matter that I'm here to discuss is orders of protection, which may not necessarily always come into play with a divorce, but do quite frequently in family court cases. And the first thing that I want to address is that orders of protection are typically issued on an emergency basis, and given court closures due to COVID-19, I just want to remind everyone that courts are open for emergency matters. And whether it's orders of protection or divorces or child custody, the courts really are open, and you should talk to an attorney if you want to go to court for an emergency reason, whether it's an order of protection, child custody, or a divorce. You should definitely speak with with an attorney about that and the different requirements that are in play to do that, because I think that there is a little confusion with people thinking that the courts are closed when really for things that are emergencies, they are in fact open. So first thing, an order of protection and what it's for. Orders of protection are essentially no contact orders that are issued by the court to stop family members or former dating partners or former household residents from contacting one another. So in these instances, we're talking about abuse, cases where people are harassing one another, physically injuring one another, making threats of physical violence, and in limited circumstances, emotional or other types of traumatic abuse. And those, again, are only issued for people who share a relationship that's protected under the Order of Protection Act, meaning they have to be spouses or former spouses, family members or members of each other's immediate family, possibly household residents, people who live in the same household, or former dating companions. The people who are not eligible for orders of protection are people that don't fall into one of those categories, right? So if someone punches you at a bar, you're not entitled to get an order of protection against that person if you never knew them before. So that, just to be clear about that. In those sorts of instances where the person is not in a special relationship with the person seeking an order of protection, that's called a Stalking No Contact order. And those can be issued for people who are not family members and don't share those special relationships that I mentioned. But there should be 2 or more instances of the conduct. So again, the hypothetical scenario of someone being punched by a stranger in a bar, that person would not be subject to an order of protection unless they did it more than once, essentially, twice or more. So we can move to the next slide. So now that we've established who they're for and why they're obtained, I want to explain how the court orders them, how the court issues an order of protection. So the first thing that I want to make clear is that time is of the essence when you're dealing with orders of protection. If something happens, whether there's a sexual assault or a physical assault, some sort of threat of physical violence or threat of concealing children, in those instances, the court wants to see the person seeking the order of protection move as quickly as possible. And if there is a delay of some kind, we need to have a reason why. And that reason ought not to be, I waited to call an attorney, or I didn't have the money, or my attorney was busy. Those are not going to be sufficient reasons. But, I went to the police first and worked it out with the police, and then they recommended that I go to court to seek an order of protection. That is a sufficient reason. I was stuck in my house and my captor wouldn't let me leave. Another sufficient reason for an order of protection. So there can be delays. We just have to have a good reason as to why. But in most instances, if there is a matter of abuse, whether or not it's a threat of abuse or actual abuse, we want to make sure the person seeks the order of protection as quickly as possible. One, because it shows the need, essentially, a person seeking an order of protection, showing that they seek it on an urgent basis, really helps support their story, but also because the court does not issue 2-way orders of protection. And in my line of work as a domestic violence attorney, I find that a person who is abusive, whether or not he or she uses their fists or their pocketbooks or the influence of friends and neighbors, whatever their method or MO for abuse, they can also find a way to make the courts another type of abuse. So they'll use the court as a weapon against the person they're abusing and then seek the order of protection that person would otherwise be seeking. And then the court would be issuing 2-way orders of protection, which it does not do. So if someone is in a true abuse situation, they want to get to the courthouse first so that they can be the one to obtain it. Because once they obtain that gold ring, the other side cannot get it. So I just want to make that clear. So we can go to the next slide. When you do go to the courthouse for an order of protection, you're going to have a summary of everything that has happened in the abuse scenario that prompted you to go to the courthouse. So you'll also have to have all the rest of your documents prepared. The first thing that you have to have when you go to court for an order of protection is a petition for order of protection, explaining who you are, who the person is, who you're seeking the order of protection against, and all their information, their address, their age, their height and weight, those sorts of things. Any physically identifying features like tattoos or glasses. And we also have to have, like I said, their address on a summons that the sheriff can serve on the person who is the respondent in the order of protection. The information sheet that the court has details the things that I listed, including a physical description, and a make, model, license plate number for their vehicle, and then a cover sheet. You should have all those things prepared when you arrive at the courthouse. And again, if you're doing this during this COVID crisis, you would want to talk with an attorney about any other requirements that are necessary. And then all your exhibits, if you're basing your petition off text messages you received that were threatening, you would want to have those text messages. You wouldn't want to delete them. You wouldn't want to leave your phone in the car. You would want to make sure that you have printouts for the court of all of the exhibits. And you should have more than one copy so that you're prepared to pass a copy to the court if necessary. And you need to understand as well that you could wait hours to be heard. You could be at the courthouse for an hour, or you could be there all day. These things are day specific, and we don't know how many people are going to go to court for an emergency order of protection in any given day. So it could take quite a long time. If you're going with an attorney, it could take quite a long time, and therefore it could be costly, and it's something to be aware of. But in those documents, you want to make sure that you set out all of the allegations that led you to think that you need an order of protection. So we should go to the next slide. There's a section of in Cook County, there's a section of the petition for order of protection called paragraph J. And that part is really where the rubber meets the road in an order of protection proceeding. That space is where the petitioner sets forth all the allegations that constitute abuse. And the best way to do that, kind of the best practice for accomplishing that, is to set forth the most recent incidents first, in terms of what brought you to court today, what's urgent, what happened most recently, and then trace it backwards in terms of reverse chronological order, all the abuse that has occurred over the course of the relationship. It could even be many years old. It's important to lay it all out there for a reason that I'll explain. Orders of protection are created by the Illinois Domestic Violence Act, and the preamble of that law states that the purpose of an order of protection is to stem the escalating nature of domestic abuse. And essentially, the escalating nature is the important part of an abuse relationship that the court needs to know about. People can get angry and lash out at their spouse or lash out at their girlfriend or boyfriend, and that could be frightening, but it may not constitute abuse under the act unless we show a pattern that the court needs to step in and intervene. So if a person starts out abusing someone in a small way, let's say verbally, and then it escalates to a matter of violence, and then it escalates to death threats, if we forgot to start by saying there were verbal abuse and then like physical abuse before the death threats, the court may not understand that this is a matter that's escalating. So setting those facts out in this reverse chronological order shows the court the most severe things first, but also how we got there and why it's important for the court to step in. At that same time, during this process of preparing that paragraph, you should gather all the evidence that you can. If your spouse called you 45 times in one night and you see that and you're typing it out in this paragraph J, print out the screenshot. It really does go a long way in terms of bolstering your story. You can get to the next slide. Next, there's a very important part here that I want to make sure I call out to everyone who's looking at this for an order of protection. That petition for order of protection asks the petitioner what the effects of the abuse are. And oftentimes, people will say terminology that we toss around, like depressed or anxious, when in actuality, those are medical diagnoses. And that's a matter of privacy. The fact that someone has a diagnosis of depression or a diagnosis of anxiety or insomnia, those are not things that you need to allege. You don't need to allege medical conditions to show that the abuse has had an effect on you. It would be far better not to use medical terms or psychological terms and instead use things like sad or fearing for my safety or I can't sleep, without getting into your own personal information that could possibly come back to bite you later during a hearing. But it is important to emphasize the effects that the abuse has had on you and your family, any other impacts that have come to light. If you've had trouble with your employment or whatnot, put that in there to show the importance or the impact the abuse has had in your life. We can go to the next slide. And then, sorry, can we go back one? Okay, and so when you do go for a hearing, you want to, again, have 5 copies of every piece of evidence that you've got, every text message and phone log. You should definitely have it with you, and come to court. Every time you go to court at an order of protection hearing, you can expect to be having a trial or having a hearing in front of a judge. So you would want to be ready as if it's the last hearing in your case every time you're in court. And oftentimes people find that for that reason alone, they want to have an attorney with them. You'll see a lot of people in an order of protection courtroom there without an attorney, but you'll also see the court not issue orders of protection to many of the people who are there. If you want an order of protection and you want to make sure that you get it, it's definitely important to bring a lawyer. At that time, when you're in court, it's important to advise your lawyer about the issues that spur off, someone to get hostile. Those are hot button issues, as I call them, the things that aggravate the person to the point where they commit acts of abuse. The reason why that's important is there does stand an opportunity and a chance that if someone asks enough questions of the abuser or of the respondent in court, that he will lash out in front of the judge the same way he does in front of his spouse or his girlfriend. So talking about those hot button issues and identifying them for your attorney can be a really good strategy to prove your point. And I just want to also say that during this time, that if you have an order of protection, it's important to protect yourself and your family. An order of protection is essentially nothing more than a piece of paper. It can have criminal penalties associated with it, and it can cause big problems for a person who violates it, but it isn't going to save you from an act of violence. So it's important to remember that even though you've obtained this order of protection, it's not the only precaution to take when you're in an abusive relationship. You can go to the next slide. Lastly, when you're drafting the order, you want to make sure that your order is clear, there's no scratch outs, and that everything that you want it to say is included within the four corners of those pieces of paper, because that's all the police or the sheriff will have to enforce your order of protection. So if you find yourself writing it or you're working with an attorney, you want to make sure it's as clear as possible. So any questions that you have about this matter, I'm happy to take them at the end of the presentation.
All right, thanks, Christy. Thanks for the presentation. And we're going to move on to the next topic, Patty Levinson. As surprising as it may seem, not all divorces are ugly, drawn-out battles, but sometimes people will try to reach collaboration and mediation. So, Patty, you want to take us away with the collaborative divorce process?
Thanks, Ted. There are many reasons that people like to keep their divorces out of court. A divorce can be handled in a kinder, more gentle manner. Emile, Christy, and Colleen all talked about decisions that courts make as it relates to dividing assets or decision-making responsibility for the children or keeping people safe. But a divorce can be accomplished with minimal court involvement. And the reasons people like to keep it out of court, so to speak, is to protect their privacy, and also so they can maintain control over the divorce. People that are divorcing had a family they created or have a family that they created. They've decided they're going to divorce. The family isn't breaking up, it's just rearranging, because many of these people have children. They're going to have to co-parent these children for many years. And it's always in the children's best interest that the parents can get along reasonably well for the children's sake. So we don't have to worry about people running into court and airing all the dirty laundry, or having a judge who is a stranger to the family make decisions that are so fundamental to what the family is going to look like post-divorce. The two most common ways to avoid court involvement in a divorce is mediation. And Colleen talked a little bit about mediation as it relates to the children in the family, but the entire divorce can be mediated. The parental responsibilities can be addressed, the assets can be divided as the parties want them to be. And how they do this in mediation is that they go to a third-party neutral who is supposed to facilitate conversation between the parties to arrive at agreements that they both can accept and live with. Nobody's going to get everything they want. We're looking more at meeting each party's needs as opposed to their wants. And the mediator assists the conversation. Now, mediation doesn't work in all cases. It's not going to work where the parties really have a difficult time communicating. And it usually does not work in cases where there's any sort of abuse or domestic violence going on. If there is a very big imbalance in power, mediation doesn't work. But it works in a very many cases. The mediator cannot provide legal advice. The mediator is there as a neutral third party. And eventually there will be attorneys involved in the process. Sometimes parties will hire attorneys as they go through mediation to assist them in the process. So they can tell their attorney, okay, we're going to talk about what we're going to do with the house today. Can you prepare me? What should I talk about? What can I expect? Sometimes the attorneys will even attend mediation sessions, usually to help if there's a bump or if the parties are stuck on something. There have been times when mediators do attend. At the end of the mediation process, at least one attorney will need to be retained to draft the legal documents that need to be presented to the court to finalize the divorce. At the end, the mediator, excuse me, is not there to offer any solutions. The mediator's there to help the parties get to solutions. Ted, can you go to the next slide? Okay. At the end of the mediation, a memorandum of understanding is prepared. And this is where the mediator sets forth all the agreements that the parties reached in the mediation process. And the process can be as quick as 2 or 3 meetings, or it can take longer and can, you know, go on over several months. But at the end, a memorandum of understanding is prepared, and then the lawyer that is retained by one of the parties, or maybe both, will draft a marital settlement agreement to divide all the marital assets and an allocation judgment of parental responsibilities to set out a parenting schedule and allocate the decision-making responsibilities. Sometimes, though, after the parties complete mediation and they go to a lawyer or lawyers to draft up the documents, some additional negotiation can be required. Oftentimes, a lawyer will question a decision that their client reached in mediation because it may be contrary to what a court would generally do. One of the benefits of mediation is that the parties can reach agreements that are different than a court would generally decide. As long as the parties are in agreement to it, and it's not unfair or unconscionable, usually courts will allow that to remain a part of their divorce. Some lawyers I have seen almost undermine the mediation process. They get a memorandum of understanding and they say, oh no, this doesn't necessarily work for you. This isn't the right thing for you. You're entitled to more or less. And they will try to undo the mediation, and sometimes they're successful at that. But a memorandum of understanding gets prepared, the marital settlement agreement and allocation judgment and parenting plan get drafted, and then the attorney will go to court and get the parties divorced. And that is the only court involvement in the process. A collaborative divorce is almost a relative to mediation. The underlying theory is the same. The parties are going to make decisions for themselves. They're going to do it without any court involvement, And they're going to do it in a series of face-to-face meetings similar to a mediation. Each party retains a collaboratively trained attorney. And here the attorneys are working together to meet both parties' needs, as opposed to in a traditional litigation setting where the attorneys are working against each other. And when you have two attorneys that are working towards the same goal, you can offer solutions that are specifically tailored to this particular family. And here, as opposed to mediation, the attorneys can make suggestions. They can offer things that might be outside the box. They can set up schedules that might not be anything that a judge would ever consider. But if it works for the family, both parties are in agreement, and the judge feels it's appropriate, it will get entered. And all the issues are addressed and settled through a series of team meetings. You have the two collaboratively trained attorneys, and you can also bring on additional collaborative professionals. You can bring on a financial neutral, and that person is usually helpful when the assets are a little more complicated, or one party has had control over the assets and the other party knows nothing really about the finances of the family. The financial neutral can help bring that person up to speed so they feel like they're able to participate in these discussions properly. The financial neutral can also prepare different scenarios as to what things are going to look like post-divorce, how certain problems might be addressed. Somebody's concerned about how their retirement is going to look. The financial neutral may be able to set out certain plans that will have different outcomes for retirement if somebody's more concerned about their immediate future. The financial neutral can address all those issues. We can also add a coach to the team, and a coach is a mental health professional that is trained in the collaborative divorce process, but they're not there in the role of a mental health professional. They're there in the role of a divorce coach, helping the parties communicate with each other through the process so that progress can be made. Very often when people are sitting in a meeting like this, old issues get brought up. Remember the time that, or when you did this, and everybody's got issues they just don't like to drop. The coach tries to keep that out of the conversation so that progress can be made towards reaching agreements. And we can also bring in a collaboratively trained child specialist. And those are especially helpful when there are problems with the child or children. And it also gives the child or children the ability to have a voice in this process. They don't come to any meetings. They will, though, meet with the child specialist. So the child specialist can act as a professional who can speak to what is in the child's best interest, which at the end of the day is really what everybody wants, is an agreement that is in the child's best interest. The collaborative process has to be transparent. The parties go in agreeing that all information and documents requested will be provided, that everything that is requested will be provided, and that the parties disclose information and negotiate in good faith. We are not strategizing in a collaborative divorce case the way there's strategy involved in litigation. We're not holding anything back for a better time when we might be able to use it for a little bit more leverage, which is often done in litigation. The idea of leverage or hide the ball or any kind of gamesmanship is off the table in a collaborative divorce. The parties agree at the outset that no disputes will be brought before the court. Again, the only time the court is involved in this is to finalize the divorce. But if for some reason the collaborative process breaks down and the parties are unable to reach agreements as to everything, and somebody says, I have to go to court, we can't do this, both collaborative attorneys must withdraw from the case. The main reason being is that during a collaborative divorce, attorneys learn more about the other side of the case than they would in a litigated matter. They have too much information. And it's very difficult to switch gears from being collaborative and working together towards a goal than being a forceful advocate. And I don't want to suggest that the attorneys in a collaborative divorce are not advocates, because they are advocates for their clients, but they're not there to do battle with the other. So it's difficult to switch your mindset to go to battle when you've started out the process in a collaborative way. So if the parties decide there's going to be litigation, both attorneys need to withdraw. Now, this is a great incentive to keep the process going, because everything that was accomplished during the process is for naught, basically. They have to start all over with new attorneys, and it really can become an expensive proposition. So this is one of the things that keeps the collaborative process going. The parties know that if they don't fight through it, and that's usually what it is, they have to fight through it, and they can succeed, and then they have a divorce that they created that was not put upon them by a judge that they don't know and does not know their family, and they can begin establishing their family after the divorce so they can co-parent their children.
Okay, thank you, Patty. And thank you, Emil, Colleen, and Christina. We do have several questions, so let's just jump right in there. This first question, I think, would be addressed to Colleen and maybe Emil. But the question is, if a couple is interested in trying to expedite and mitigate the costs dealing with maintenance and child support, what are your suggestions for them to accomplish that before they file the divorce?
Different issues, right? So for maintenance, what you could try to do to mitigate your exposure to pay somebody maintenance is, as simply as just having that other person try to become self-supporting, right? So if you, for example, are married and live with a stay-at-home parent, you would try to find employment for the other parent so that they're self-supporting. I mean, or if you want to not pay maintenance, another option would be to just buy them out of it. So for example, you would do the calculation to see how much this person would be getting in maintenance if they were awarded that, and sort of extrapolate that in a way that where you could buy them out. So for example, if over a 10-year period, this person would get the equivalent of $200,000 in alimony, you could essentially say, look, I'll pay you $80,000 today, and that'll terminate, they'll waive, that other person would then sign a waiver waiving their rights. For child support, it's a little bit different. So child support is really, there's not much wiggle room, so to speak, in that. The only way you could essentially minimize exposure to that is to have 146 or more overnights with the child or children. That way you're paying a significantly reduced amount of child support. But those are essentially the two most common ways of avoiding those two issues.
Hey, Colleen,
yeah, I do. If we're talking about not necessarily limiting exposure, but expediting the process of maybe having a child support obligation in place, obviously the best way to do that is by agreement. You can enter something called an agreed order, which provides for child support, which can be calculated out fairly easily based on the statutes. So if the parties can come to an agreement as to what the calculation of child support is and who should pay which party, that's something that can be entered in an agreed order right away as soon as that agreement is entered. If you can't get that agreement, I would say as soon as you can, you could do this at the outset of the case, file a motion for child support and get that heard as soon as possible. Child support can be paid on a temporary basis, meaning during the pendency of the case. And then beyond that, it could be a general child support award once the allocation judgment is entered.
Okay, thank you. Next question, and this probably should go to Emil, and it's dealing with life insurance. If one of the spouses have a life insurance policy on the other spouse, when can that party cancel that life insurance or change that life insurance, especially when you have a minor child?
Right. So in the pendency of the divorce, so while the divorce is still active, the courts are typically going to require the parties to keep things status quo. So if you have insurance policies or healthcare benefits or whatever, the courts will want you to keep those same beneficiaries, same people that are involved or participating in those plans. Now, life insurance, though, sometimes the courts will require somebody to maintain that for the benefit of that other spouse, even after the divorce, if that party has an obligation to pay that other spouse support, whether it's child support or maintenance. And so they want to protect that. So in case you die before the child reaches the age of 18, for example, the courts will want a set of money set aside in the form of like life insurance, for example, to be able to pay that other spouse or their other parent child support, even though you no longer can pay because you're deceased. So life insurance is used in various ways, but you shouldn't be able to, you cannot change beneficiaries until typically after the divorce is finalized. Thank you,
Emil. Next question, this is for Patty, and this is dealing with the collaborative process. I think the question is, is the attorney in that, is that a neutral attorney, or do both spouses have their own attorney? Can you comment on that, Patty?
Yeah, both spouses have their own attorneys. Collaboratively trained, they are not neutrals. They are advocates for their clients. But when other collaborative professionals are brought into the team or onto the team, a financial neutral, a coach, or a child specialist, they are usually in a neutral role. The financial neutral is always neutral. They are considered a neutral party. Sometimes one coach is used, and that coach would also be considered neutral. There are times, though, when each party has their own coach, and then the coaches wouldn't be neutral. But unlike mediation, the discussions are had, the meat of the discussions are had with attorneys who are advocates for each client, but are working together towards an agreement that works for both parties.
Thank you. Next question is for Christy. Christy, can you comment on the difference between the order of protections that you obtain on behalf of your clients versus an order of protection that may be obtained through some sort of criminal matter, through a prosecutor? Can you comment on the differences?
Yes. So an order of protection issued civilly is the kind that I obtain for clients. Those are ones where the person would go in, the petitioner would go into the courthouse and seek an order of protection. The criminal orders of protection to which you're referring are part of criminal cases wherein an abuse survivor as a crime victim will work in conjunction with the Cook County State's attorney or the prosecuting attorney in whatever county they're in, and obtain an order of protection in that criminal proceeding. So essentially, during the pendency of that criminal case, whether or not it's domestic battery or sexual assault, attempted murder, there could be any number of criminal scenarios. The person who is the survivor of that abuse crime can be protected during the pendency of that proceeding by what's called a criminal order of protection. Those are very similar in the penalties, but they come in a totally different way, and they would be in conjunction with the state's attorney, the prosecuting attorney, in that criminal proceeding. I do want to note, in those instances, you wouldn't typically have a civil attorney, although it's a good idea to talk with one in that scenario. And there is no cost associated with that as well.
Thank you. Next question. This is for Emil. We have a situation where the couple have a joint piece of real estate, joint property. One party uses separate funds, separate non-maritable funds to improve that joint property. In the setting of divorce, how does that spouse get credit or obtain credit for that use of non-marital asset?
Yeah, so there would be a presumption that the money that was used from this non-marital account to fund or pay into a marital asset, the courts would typically presume that that was a gift, and so that would not be reimbursed or credited. However, if you can trace that back, so the person that wants that money back or wants the credit, so to speak, they can trace those funds, but they would still have to show that there was no intent to gift that money into the marriage. So a simple way to avoid that would be to have, for example, like a premarital agreement or a prenup, as we call it, or another agreement between the parties to indicate that even though they're using non-marital money to fund or contribute towards a marital asset, that in the event something happens, that they would get reimbursed or credited back.
Thank you, Emil. Next question is for Colleen. This deals with the scenario of perhaps one spouse or even a father that may have been no longer involved, or one mother or father, I guess, for that matter, in a case where there's been drug addiction and grandparents are now having custody. Is there any right to go after the father or mother for child support in those circumstances?
So the general thing here is only the blood parents are the ones that should be on the hook when it comes to child support in this instance. Looking at the question, it does seem that there are also some issues related to guardianship as well, which is separate from family law. When we're talking about grandparents caring for a grandchild because mother isn't able to, or parents isn't able to. And I'm happy to talk about that offline. It's a little outside of the realm of family law, but just to give a quick explanation. In probate court, a non-parent can seek something called guardianship, meaning decision-making for a minor child if both parents are unable to properly care for the child in that instance. It's meant to be temporary, it's not meant to be permanent, and it's a little bit different than custody or parental responsibility that we see here in family law. But by and large, when we're talking about purely issues of support, only the biological parents should have a duty of support to the child.
Thank you, Colleen. And with that, we're going to end today's broadcast. I would let everybody know that a lot of these questions that you may have are really fact specific. So in those situations, it may be best to have a more extensive conversation. By all means, feel free to email us at info@lavellelaw.com. Also, you can call us at 847-705-7555. We'd be happy to provide any new potential client with a free consultation and kind of go through any of their concerns, any of these topics discussed today in a more in-depth way. Hopefully you enjoyed today's broadcast, and we will be publishing this through YouTube in the near future. And thank you again. Thank you, panelists, for joining us. Have a great day. All right, everybody.
Okay.
Yeah, thanks so much, Ted. You did great.
All right. Take care.
Bye.
Bye.